Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Perry.
Good morning, Judge.
Waiting for Ms. Butler to connect to audio and we can get started.
Okay.
All right. Can you hear me, ma'am?
Yes, good morning, Your Honor.
We are on the record. This is file number 06-140-415. The file is entitled Asset Acceptance versus Pauline Butler. Date and time for objection to garnishment. Your appearances.
Good morning, Judge Andrew Perry, P69402 on behalf of plaintiff.
And what is your name, ma'am?
Pauline Butler.
Ms. Butler, you are the moving party. What is the basis of your objection to garnishment?
Okay, for one, they never sent me the original letter telling me to go to court about, before I get to garnishment of wages. They sent the mail. They said that they personally delivered it, but the mailman, even on their paper, said that he could not give it to me because I didn't stay there. I even got papers from the Detroit Land Bank when I brought my house saying I stayed at 8208 Winkleman. I didn't stay at 8137 Winkleman. I stayed there many years ago. But then I had moved to Arcola Street, and then I moved back to 8208 Winkleman on the same block, the same street, but not in the same house. They never gave me anything. And also, I really don't think it's mine because at the time, 2007 and 2006, I already had my DTE. I had DTE on since 1988, since I was 18. Only got it cut off one time, and I got it turned back on, and that was with Razor Capital, and I got it right here, and I paid them off.
Okay.
And also, they like I said, I never received it. They said they personally hand served me the letter, and I was not there. And they don't even have my middle name right. They got Kate. My middle name is Katie, but I'm like, how can I owe DTE when I've always had DTE?
Okay.
And if they had given me the letter, I would have came to court because I would have had the DTE paper showing I had DTE.
All right. Let me hear from Mr. Perry.
Judge, the only issue today is whether Ms. Butler has a valid basis to object to the garnishment. Pursuant to MCR 3.101K1, the objections may only be based on the garnishment proceeding itself and may not be used to challenge the validity of the judgment that previously entered. She's failed to state a valid basis to object to the garnishment. Her objection should be denied and all withheld funds should be released to the plaintiff.
Okay. Court's prepared to rule in this matter. Ms. Butler, the register of action here indicates that you were personally served with summons and complaint in September 24, 2006. Thereafter, on January 18th, 2007, the judgment was entered by default. A judgment lives for 10 years. In November of 2016, less than 10 years after the date the judgment was entered, that judgment was renewed. So the matter before me today is your attempt to attack the underlying judgment. And you may not do that by virtue of a objection to garnishment. The court rule counsel cited is correct. Michigan Court Rule 3.101K provides that you may not use the objection to garnishment, which is the only matter before the court today, as a means of attacking the underlying judgment. Having failed to state a valid objection to garnishment, your objection to garnishment must, of course, be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you in order. Thank you both for coming in. We are off the record.
Thank you, Judge. Have a nice day.
Yes, sir.
Thank you.